Outlaw Lawyer.
Welcome back to the Outlaw Lawyer. Morgan Patrick, consumer advocate, joined on set by Josh Whitaker and Joe Hamer, managing partners at Whitaker and Hamer Law Firm. Again, practicing attorneys here in the great state of North Carolina. We talk legalese each and every week, and we have special guests, also attorneys at Whitaker and Hamer. Cassandra Nicholas is here, and Taylor Scruggs-Smith. And we've had a lot go on in the past week, and we're talking about it, and we're going to start with Roe v. Wade.
Before we get there, I was thinking about something I wanted to share with everybody.
It's your show.
Literally, you can do whatever.
So, so I figured all this out Tuesday. We talked about how Monday we were at the Hurricanes game.
Yeah.
Great game.
It was a great game.
Was very happy.
It was a very fun time.
It was.
For the Hurricanes in particular.
So then went home, went to bed, woke up Tuesday morning, figured out, this had happened. And it's very interesting, fascinating to attorneys. So we spent the day kind of talking about this. I went home and kind of talked to my wife, and my kids were asking questions because they're old enough to kind of watch the news. Sure. We're talking about it. And I shut everything down because I don't know if you're aware, but last night was the premiere of Holy Moly, which is a very great show. The Holy Moly people haven't paid me to say that. I feel like I need to share that with the general public.
I saw your Facebook post about it.
Yeah, I was on Facebook and I saw
his Facebook too. I was like, excited. Josh is awake.
So me and the kids all hunkered down and we watched Holy Moly featuring the Muppets, and it was a nice break. It was a nice break. I went directly to bed after it was over because that's late for me.
What is 7:30 p.m. it ended?
His Facebook post was almost 9:30.
I know.
Yeah.
I was shocked. I was like, Josh is awake? What is going on here?
It sold me.
So Josh, a review very quickly. Holy moly, go.
Greatest show ever.
It is the finest show on TV, I think.
Today or ever?
Not ever.
Okay.
Not ever. I think today.
Simpsons, are you kidding?
But I just feel like I need to bring that to the general public. This is a very serious show this week. Not going to be a lot of joking, but that's a fun family show. There's not a lot of fun family shows anymore.
Yeah.
Yeah.
Right. I mean,
well, can I mention one thing about the hockey game?
Mention several things.
Your managing partner created and I guess committed an ultimate no-no when it comes to playoff hockey. There was a Boston Bruin fan invited into our area.
what he was.
I don't think he was invited. I think he just wandered.
He wandered right to you, Joe.
Look, it was fantastic.
He was a very polite fan, and that's shocking for Boston.
He held it together. You just didn't give him enough time. I actually thought it added, being able to see the sadness on his face was a great addition to the environment overall. The hope, the despair, like it just all the hope drains out of him.
And let's remember too, it's a series. It's not a one game.
It is a series, but that one game we went to,
awesome.
Can always hold that. Just not watch the rest of the series.
All right, back to serious stuff. Right. I felt that we needed that. I feel like not only can Holy Moly entertain my family, I felt like it could bring us some levity in the middle of a very serious discussion.
Do a Holy Moly episode.
We'll
live
focus
on a putt-putt course.
All right. So before we talk about the leak, and here's what leaked. So here is the, I guess this doesn't work on the radio, but if you're watching us on YouTube, I got a big old, how many pages was this?
98.
98-page stack of documents. This is what leaked. And so this is what we've all been poring over. But before we get to what might be, we need to talk about where we're at right now, where United States abortion law rests right now. And to do that, you have to talk about Roe v. Wade. And so we've talked about it on the show before, but Cassandra, what happened in Roe v. Wade?
So Roe v. Wade was a 1973 case in front of the Supreme Court. The right to abortion had never been recognized before that point in time. And that decision reached the protection of the right to abortion through privacy rights. So there's a whole line of cases that I know Taylor's studied more recently than me that extends from those privacy rights as well.
I think study is a strong word, but
Mastered would be a better phrase.
they're all just trying to make me look good. So I think that kind of goes back, I think, towards, I believe it's Griswold v. Connecticut, and there's kind of just a line of cases from there where the Supreme Court kind of said, okay, because of these rights and that are codified in the amendments to the Constitution, there seems to be a sphere of privacy that the drafters intended. And so by combining all these rights, we're going to say that there's a right to privacy, and they did that a little bit through the due process clause as well in the 14th Amendment. And so there's been a line of cases since then that dealt with marriage, interracial marriage, the rights to contraceptives, the right to do what you want in your own bedroom, several cases like that that have kind of led up to Roe v. Wade, and that was kind of the privacy right that was involved in that.
So you usually have, and we've talked about it on the show before, but you usually have two kind of judges, two kind of justices. You have your Supreme Court justice who's going to strictly interpret the Constitution. So, it's like, if it's not a specifically enumerated right, they don't want to read stuff into the Constitution. So there's the type of justice that's like, hey, we've got our Constitution. The founding fathers knew what they were doing, and this is what it is, and we can interpret it, but we're not it's not our job to add anything to it, subtract anything from it. It is what it is, and we'll interpret that way. And then you've got a line of thinking other justices who will say, the Constitution is a living, breathing document, and we're using it to govern 200 years into the future. They could have never imagined we'd have these problems and are these issues, and we need to address it as best we can based on the foundation that we have. And so those two lines of thinking are often what the justices, when they're not agreeing, that's what they're not agreeing on. And like Taylor said, there's a whole line of cases where the court has really struggled because obviously the Constitution doesn't talk about married couples' right to contraceptives,
right,
interracial marriage, things that the founding fathers were not dealing with immediately when they wrote the Constitution. And so the court has struggled to say, hey, we need to address these things. It's not, an amendment, right? It's not strictly in the Constitution. And so they've created these rights that I would call them implied rights. Yeah. The Constitution protects this, this, and this, so it makes sense that it would also protect this.
And it is that constitutional interpretation that is at issue here. The Roe v. Wade decision explicitly incorporated modern context as one of the factors that they were looking at. So they specifically, one of their factors in the Roe v. Wade decision was the demands of the profound problems of the present day, which justices that are strictly interpreting the Constitution would never put that line in the decision.
Right.
And that's part of the sticking point of Roe v. Wade always been, is that people have said, okay, this isn't an explicit right. How did they even get to this? That type of kind of balancing act between those two types of interpretation theories is what's kind of led us to Roe v. Wade in the current case before us.
So what did Roe v. Wade, what was the rule of law after Roe v. Wade? What did Roe v. Wade institute?
So it did establish the trimester system of pregnancy, which had been referred to previously, but not in a Supreme Court decision, not by law. So then using that trimester system, it established kind of a viability of the fetus standard for when abortion needs to be protected as a right and when the fetus now has rights. So that's where it was.
That's created a sticking point for people that has lasted to this day.
Right. So you in any of these decisions, we're always talking about competing interest. And so usually when you have something being litigated, Supreme Court level, district court level, small claims court, it's because you have two groups or two people with competing interest. And so a judge, a justice, they're going to have to decide basically who's more correct. A lot of times you've got two sides that make really good arguments, but there has to be a general rule of law, or there has to be a point where and I think that's what they're doing here. You've got people who are like, hey, look, maybe some people believe at conception, an unborn fetus has rights. That's a life, and there may be religious reasons people believe that. Maybe completely non-religious reasons people believe that. But there's people who are like, the state has an interest, just like those folks would compare it to like a murder, right? You have an interest in protecting a life, and so if you're seeing this unborn fetus on day one as a life worth protecting, you're going to be an anti-abortion activist because you believe you have to protect the rights of that unborn fetus, right? And on the other side of the argument, you've got a fine argument that a woman needs to be in control of reproduction to live and work and be an active American. And those interests are what's butting heads, and people are very solidly
On one side.
Side or the
one side or the other. There's not a lot of people like in the middle, like, I don't care what.
Well, maybe there
happens.
are. They just those aren't the crazy people that are going to go on Twitter or go somewhere and just like really push that opinion because it's
Crazy or passionate?
crazily passionate.
And I think there are some people in the middle who are like, okay, maybe there needs to be some government control,
Right.
but not to this extent. And I think that's the only kind of middle you have.
Yeah, and that's it. That's like you said. Those are the people who, on any issue, the ones that fall more towards the middle are the ones that get drowned out by the echo chambers on either side.
And I know it's amazing. I was not alive in '73. I'm not quite that old.
Just
so
barely. You were a viable fetus then.
So I can't report on what was going on in the nation at that time, but this was a hotly contested issue, and it had been for some time.
Still is.
Still is.
It had made its way to the Supreme Court. So the Supreme Court was a more liberal leaning Supreme Court at the time, but they were like, hey, this is an issue. The country's looking up to us to make this decision, and for better or worse, depending on what side you're on, they made a decision where they tried to go. I think try to make both sides happy.
Kind of strike a balance.
Yeah.
So from 1973 until 92, states were required to not make abortion illegal, but they could make it very difficult.
Which is how we got to Casey.
Yes, exactly. So the case of Casey in front of the Supreme Court in 1992 made it so states couldn't place undue burdens on the right to abortion. So states previously were implementing things like requiring women to hear the heartbeat before they could go through with abortions, or having waiting periods.
Or if you were married, you had to tell your husband and he had to come in and sign consent. Or sometimes even if you weren't married, depending on the state, the father had to come in and sign and agree. Definitely that waiting period. Some states I think had it up to like 48 hours of a wait period, and you had like classes you had to do beforehand. They made it really difficult for that right to be used in any way. So the court had to readdress it.
So in 92, Casey reaffirmed the right to abortion, reaffirmed Roe v. Wade, and then also added that standard restricting states from placing undue burdens on that right.
And so that's the way it's been, right? So there's been cases every year that come up where the Supreme Court has to look at something a state has done to maybe put up roadblocks or to make it even more difficult. And the Supreme Court has had to say, okay, well, you can do that, but okay, you can't do this. And so there's this whole lineage of case law after Roe and after Casey that have kind of, minutia, right? This will work, this won't work. And there's a lot of states out there that spend a lot of time trying to craft legislation, like you said, to make it as hard as possible. And if you're against abortion, then you're good with that. You trumpet that, like that, and the court will strike down what they can. But
at the same time, Roe v. Wade, by and large, has been settled since that point. This is the first time you've seen.
Yeah, so we're 50
drastic.
And it actually came up a lot in the confirmation hearings. So some news outlets and senators are starting to come out saying like they don't know how to feel about the confirmation hearings that went on, because this was brought up several times with a lot of these new justices' confirmation hearings.
But none of them lied.
None of them lied.
They successfully lawyered their answers.
It depends of the lawyers.
It wasn't even, it depends. They said, this has been settled law for 50 years. They didn't say they weren't going to do something about that.
Right. So nobody lied. Everybody did their job right.
And we'll talk.
Lawyered.
They lawyered.
And we'll talk about
At least in that area.
We'll talk about settled law, and we'll talk about stare decisis, and we'll talk about a lot of other Latin legal terms that are super fun and exciting to talk about next.
All right, guys. The Outlaw Lawyers, Josh Whitaker and Joe Hamer. You can find them at Whitaker and Hamer Law Firm. They're the managing partners there. Again, practicing attorneys here in North Carolina. In studio with us, returning guest, Cassandra Nicholas, also an attorney at Whitaker and Hamer, as well as Taylor Scruggs-Smith, also an attorney at Whitaker and Hamer. If you've got a legal situation that you're dealing with and you've got questions, I've got a phone number for you. You can get in touch with Whitaker and Hamer. It's 800-659-1186. That's 800-659-1186. and just leave contact information briefly what that call is about. An attorney with Whitaker and Hamer will be in touch. And you can always email your questions to the Outlaw Lawyer. It's questions@theoutlawlawyer.com. And we have a wonderful website, again, theoutlawlawyer.com. We're back right after this.